Hi, I'm Soraya Marshall Wright. Welcome to The World According to Soraya. For those of you who do not know, I'm an elder law and special needs planning attorney in South Carolina, and I help families plan for the unexpected and protect their valuables. All right, so we're continuing with our April Fool's series. Last week, I told you not to be fooled by your close family relationships, because the best way to ensure your wishes are protected is to write them down. Not just talk about it, but be about it. This week, we're going to talk about circumstances in which you may wish to revise your estate plan, even if you think they meet all of your needs and clearly spell out what your wishes are. All right, so if you've been following me for any length of time, you probably know that I love explaining concepts using random stories. So today is one of those days. Let's talk about Paul. Paul has a little sister named Paula. Paul and Paula are very, very close. Their mother passed away when Paul was 19 and Paula was 15 years old. And Paul has always vowed to take care of Paula no matter what. So he decides to have an estate plan done. In his will, Paul leaves all of his assets to Paula because, of course, he loves his little sister. He wants to make sure she's taken care of no matter what. Fast forward a few years, Paul meets Martha, and Paul decides to get married. Now, Paul and Martha have had this conversation several times. She understands that, hey, if something happens to me, I want all of my things to still go to Paula. He doesn't bother changing his will. His will obviously says he wants all of his things to go to Paula. Well, unfortunately, Paul passes away. And after Paul dies, Martha completely forgets the conversation that she and Paul had about wanting all of her things to go to Paula. Or did she? So Martha can actually petition the court and say, hey, court, guess what? This estate plan, this will that you've taken in, it was drafted years before Paul and I were married. I should be considered an omitted spouse. Yes, in the state of South Carolina, an omitted spouse is basically someone who's claiming that their spouse created an estate plan before they were married, and therefore they're still entitled to a share of that estate. So in this scenario, even if Paul wanted all of his assets to go to Paula, Martha is technically entitled to 50% of that estate, and she can get it no matter what the will says. So don't make this foolish estate planning mistake. If you have a life-changing event, be sure to revise your documents and make sure the people you want to be protected will remain protected. All right? So, if you didn't know that failing to update your estate plan after a life-changing event could completely derail your plans, now you know. And I'll see you next time.